Any mention? Item number 1.
Yes, Mr. Demnat, Mr. Appellant.
My lord, I want to seek for time, my lord, since the conducting counsel is on leave.
Yeah, objection.
No objection, Your Lordship.
But only in condemnation, correct?
Condemnation, your
Then
lordship.
what is the, how much the delay?
103 days.
Where's Demnat?
He is in kitchen under the courtroom, Your
Do you
Lordship.
have any objection to condemnation?
We have objection, your lordship. We have filed an affidavit.
Then let the senior counsel appear.
After 2 weeks,
The mention is made on behalf of the arguing counsel for the respondent. He's on sanction leave.
my lord.
Who's on sanction leave? Just after
2 weeks, your lordship.
2 weeks. Yes.
Oblige.
Next time we'll take out a condemnation matter.
My lord.
Item number 2.
May it please Your Lordship, I appeal for the petitioner.
Lord, it's been 7 months the respondents have
filing our
not.
affidavit today. We'll be filing our affidavit today, madam.
Lord,
Today? Who's your local counsel? Me. Oh, you appeal. You have received copy?
No, no, no.
But for 1, 3 and 5 also we tried to file, affidavit is ready, my lord. Friday there were some issues with the NHS. So we are trying to file it today also.
We'll do one thing, Mr. Ghosh.
yes, my lord.
Since the respondents number 2 and 7 are filing today, and the
We also, 1, 3 and 5.
1, 3 and 5 filing by tomorrow. So let us give them a chance. If you look at the affidavits, and we'll try to dispose of next date.
Very well. Then, my Lord, may keep it on 10th of March, subject to
10th of March,
convenience.
yes.
Lord, rejoinder if any.
Yes, by yes, Mr. N. Sincon, on behalf of respondents 2 and 7, submits that the affidavit on behalf of said respondents will be filed in the course of the day. Mr. Dr. N. Mozika, for respondents number 1, 3 and 5, also submits that affidavit will be filed within 2 days. So, in that view of the matter, this is matter 10th March, rejoinders, if any, to be filed in the meantime. Yes.
Lord, the interim orders will be continued.
Interim order, if any, should continue the next date. Yes.
Obliged. Lord, my Lord, may put it for final hearing on 10th March, subject.
Well, endeavor shall be made to dispose of the matter on the next date.
Okay, I'm so obliged. I'm so obliged.
Hearing item number 3.
My lord, for the petitioners, my lord. Shall I take my case, my lord?
Who's for the other side? Ready? Yes.
Yes. My lord, the case is, if I can put my case in 2 lines, my lord. The annexure A17 adjudication order.
1 second.
Yes.
Yes.
Well, my case in 2 lines is there.
In 2 lines?
In 2 lines, if I may brief, I have a very short summary of my case. Is that my the A17, annexure A17 adjudication order is in violation of the annexure A16 master circular issued by the Ministry of Finance.
1 second. A17 page.
A17, my lord, your lordship will find running page number 129. 129 is the impugned order, annexure A7.
Yes.
And this is in violation of the annexure A16 master circular issued by the
This is
Ministry of
original
Finance.
order.
That's an order in original. Order in original.
Okay. Is dated. You dated
21
June.
6, 2024.
Is in violation of.
Is in violation of the annexure A16 master circular issued by the Ministry of Finance.
Okay,
That
let us
starts
see it.
from 105. 105. That's where the annexure A16 circular starts. And the specific violation can be found.
Just go a little bit slow. We're not as fast as you. So just
Sure.
come easy. Yes. 105. What does the Master's Circular prescribe?
So, if I may take your lordship to page 170, this Master Circular deals with adjudication procedures to be followed by the Department of
Master's
Customs and
Circular on
Others.
show cause, notice, adjudication, and recovery.
Yes.
Okay.
And if I may
Page?
take you to page 117, page
Okay.
117.
Okay. Yes.
The fourth last line from the bottom, Mike.
Personal hearing.
Yes. Personal hearing, but the fourth last line from the bottom, it reads,
Yes.
if in fact separate letter for each hearing / extension should be issued at sufficient interval.
Yes. Yes.
It's very clear. In fact, now let me take your lordship to page 95, running page 95 of the writ petition matter.
$95.
95.
Is a postal receipt.
It is a postal receipt. It is a postal receipt that dates as 7/6. Now 7/6, the 7/6, the postal receipt dated 7/6 intimates the hearing for 13/6.
7/6/2024.
7/6/2024.
Intimates the hearing for
13/6. So the postal receipt proves that the letter was sent on 7/6.
yes.
And now, if I may take your lordship to page 100, 100. 101.
Yes.
Page 101. That is also a postal receipt that intimates that says that it was sent on 7/6,
Yes.
and that intimates the hearing on
20th.
20th.
Yes.
Now, if I may take your lordship to page 104. 104.
That's also 7/6.
7/6. So my point being that when the circular specifically states, and as per section 153 clause 2 of the Customs Act, 153 clause 2 of the Customs Act, my lord,
Yes.
it says every order, decision, summons or notice or any communication shall be deemed to have been served on the date of it, date on which it is tendered or published. And clause 3 reads, when such an order, summons, notice or communication is sent by registered post or speed post, it shall be deemed to have been received by the addressee at the expiry of the period normally taken by such post in transit unless
One second.
contrary.
One second. Let's get a Customs Act. Who's the local counsel? You can list of books.
Your Lordship, they have given me list of books only just.
Why?
So the date on which it is sent, my lord, the conspectus.
Let us read and appreciate it first.
Yes.
Every order, decision, summons also. Okay. Okay.
And clause 3 reads, when such order, decision, summons, notice or communication is sent by registered post or speed post, it shall be deemed to have been received by the addressee at the expiry of the period normally taken by. Now, when the regulation, when on page 117, the Master Circular clearly says that each and every communication for personal hearing has to be sufficiently spaced. How can the department send the two different personal hearing notices on the same day?
For two different dates. One on 7/6, the first one's on 13th. And on the same day, again on that day, on it's posted for 20th. That's your case.
Yes. And the same, 7/6, again they send a letter for 26. Now, my lord, this shows undue haste, and undue haste is a ground for, and this is in violation of the master circular, and also the ground. I am taking the constitutional law and administrative law ground of undue haste that is referred to in decisions Zenith Mechaplast versus State of Maharashtra, and I think my local council will have the copies. I request her to.
We're going to copy to other side?
Yes, yes. Well, that may kindly.
Yes.
Now, I'm relying on Zenith Mechaplast and Bahadur Singh Lakhubhai Goel.
Paragraph?
Zenith Mechaplast, my lord, para 39. Zenith Mechaplast is 2009 10 SEC 388.
Yes.
And para 39, if I may read, my lord, it reads, anything done in undue haste can also be termed as arbitrary and cannot be condoned in law.
Okay. Yes.
That's Zenith Mechaplast, my lord. The second decision I am relying on is Bahadur Singh Lakhubhai Goel. That is 2004 2 SEC 65. I am relying on paragraph 25. 25 reads, my lord, in SP Kapoor versus State of HP, this court held that when a thing is done in a post-haste manner, malified would be presumed, stating the post-haste manner in which these things have been done on so-and-so date suggests that some higher-up was interested in pushing through the matter hastily.
Yes.
And malifieds in such situations are to be presumed. That's all. That's my view.
What is the subject matter of your case? With regard, what is the issue in contention?
This is an adjudication, my lord. In fact, jewelry was seized from my clients.
What was seized?
Gold.
Jewelry.
Jewelry was seized from my clients, and these are not even. This is pure jewelry worn on the body
person.
of my clients. Yeah.
Yes.
There was no concealment whatsoever. There is no ground for the customs to take it in the first place. But I am not entering the merits at all. I am only interested in the procedural aspects of it.
Okay.
Yeah.
That's it. Yes,
That's it. That's
Dr.
all.
Mozika.
That's my case.
But before answering that particular issue, that when notices are issued, my lord, now merits will be slightly relevant, my lord.
No,
But-
my lord, absolutely.
Please,
I'm only
please.
Yes.
No, one thing, Dr. Mozika, if that
I'll
is the
come to this.
prescription, no, just listen to the court. If that is a prescription, that every individual date of hearing has to be communicated separately, correct?
My lord.
Informing the person about the next date of hearing. Now, how can you explain that on one postal date, that is 7/6/2024, one notice is for 13th, one's for 20th, and one's for 26th, where three separate notices posted the same day? How do you get over that? Because if that is the case, that means
My lord,
palpably there's an undue haste is apparent on the face of the record itself.
I'll try to answer that question also, my lord. But before that, I'll just take your lordship to one
Okay,
aspect.
let's hear the merits, but the things that do not think the merits will sway the court, because if it's a procedural irregularity,
No, my lord,
which is
that
in
is
the
not
face
my
of the record,
that is not my intention, my lord.
then
My lord, there are some other aspects of this matter, my lord. This matter is not as simple as it is projected by the petitioners, my lord. Now here, my lord, this is a case of seizure of 1.3 kg gold, and 5 persons are wearing that much gold, my lord.
1.3 kg each.
5 of them, my lord. 5 of them, my lord. So one person is wearing. Now, your lordship will see one bangle is of 245 grams. That is some 25 tola, one bangle. And what is the form, my lord? It's a semi-finished and coated with silver, my lord. And going from Manipur to Guwahati. If something goes from Guwahati to Manipur, is understandable, my lord. When something is coming gold from Manipur to Guwahati, that's the aspect of the matter, my lord. Now here what happened, my lord? Few dates are relevant. I'll just place few dates, my lord. And this was a seizure at Manipur, Imphal airport by CISF, my lord. And
Done which year?
the date of seizure is 23 February 23.
CSS 23.
February 2023.
Okay.
Thereafter, my lord, a so-cause notice was issued to them on 21/8/23. Now, a similar matter came to your lordship recollect. Because of law and order issues in Manipur during that period, the post offices were closed and the so-cause notice was dispatched slightly later. Now, section 110 of the customs mandates that so-cause notice, if so-cause notice is not issued within 180 days, the goods have to be returned. Now, they filed a writ petition in Manipur High Court that so-cause notice was not issued to them within 180 days.
They filed.
The petitioners, my lord. I am also on this aspect, my lord. For one purpose, they are approaching Manipur High Court. For the second purpose, they are approaching this honorable court.
My lord, that writ petition was allowed. That writ petition was allowed.
I'll just
One second, Mr. What's his name? Musa. Yes, just relax. Yes. Let him finish. Yes.
Yes.
We'll hear you. Don't worry.
So, my lord, that is one aspect of the matter that they are choosing forum for different purpose, and there is a game plan, my lord. I'll place that why they've come to this honorable court, my lord. Now, the Manipur High Court, by order dated, this date will be slightly relevant, my lord, 23/7/24,
Yes.
directed to release the gold because taking that the so-cause notice was not issued within 180
Faulty,
days.
yes.
Now, my lord, coming to the notices, my lord. Now, your lordship has noted the so-cause notice was issued on 21/8/23, my lord, and we are down the line about 9 months now, my lord. The dates of personal hearing are fixed, so they are aware about the so-cause notice, my lord. Only at the most they can say that they are not aware about the date of hearing. So-cause notice, they are not denying that they have not received so-cause notice, my lord, and that also 8 or 9 months back. It's only of date of personal hearing. Now, lordship, 3 notices. My lord, kindly note the dates, my lord. These 3 dates. First notice was dated 29/5/24.
Okay.
For fixing the date of hearing on 6/6/24.
Okay.
Second notice is dated 6/6/24.
Fixing on
13/6/24. Third notice is 7/6/24.
7/6/24.
7/6/24.
Well, that's one day after 6/6.
But fixing the hearing on 26/24.
No, see, if we say 6/6/24 is the second notice,
My lord.
fixing it on 13/6, correct?
My lord.
So 13/6 hadn't happened, and how can you issue notice on 7/6 then?
But in my humble submission, issuing notice for personal hearing, my lord, it is
Personally,
not that the order.
How do you know that the proceedings won't have culminated maybe on 13/6?
But my lord, if your lordship looks at the right hand side column, it is properly spaced. 7 days time is given.
Fine. You can understand. You say 29/5/24, understandable, fixed on 6/6/24. Now on 6/6/24, maybe nothing happened. So again, we fix on 13/6,
My lord.
which is just a week after.
My lord.
Then, but how is it possible next day after 6/6/7/6/24 you issue notice for 26? How? When 13 hadn't come.
Well, 13 hasn't come, but
Then
3 notices are required. My lord, we issue 3 notices.
No,
My lord,
see, it doesn't mean that's just a cover up, just to show, just to meet a formality.
My lord,
That you issuing that you already have a determined notion of how you're going to deal with the matter, and so just to comply with the, whatever.
My lord, the department has explained the gold. I'll not use the word smuggler, my lord, but how they appear for personal hearing, my lord. The department has experience of this.
No, department
My
will
lord,
do whatever.
but my lord, what is more important, my lord? My lord, only one important factor, my lord. My lord, when they received these notices, my lord.
Yes.
Kindly see, I'll just point out when they received notice, my lord. Page 104, my lord.
Yes.
There's a round rubber seal, my lord. This dated 12/6/24.
Yes. Where is this place of
It's a
receipt mark?
Mallapuram, my lord.
Okay.
Now, if they receive, we presume that it was delivered on 12, my lord. If they can deny that it was not delivered to them on 12, it was delivered after 20th, and date of hearing is fixed on 20th, my lord.
How do you know? It's 104.
Page 104, my lord.
Where can you get it that this is?
There's the round seal, my lord.
No, that I can see.
Of Mallapuram, 12/6/24.
12/6/24. Okay.
So we presume that it was delivered on 12th, my lord. Latest on 13th. Date of hearing is fixed on 20th, my lord.
20th?
To 20.
Where you get that?
My lord, third notice is the date of appearance was 20th June, my lord.
Not 26.
26, my lord. 20th June.
No, just come. Where do you get that from?
In the body of the notice, ma'am.
No, right.
In the
102.
body of the notice, page 112, 102.
102, your lordship will see. The date of hearing is fixed on 20 June 24. Second line, my lord. And they receive it on 12 June, my lord.
Yes.
So, my lord, in my humble submission, this is purely a matter of afterthought, my lord. Once an adjudication order has been passed, now on these technical grounds, my lord, and how they've been prejudiced, my lord. At the time of seizure, they could not produce a single document.
Okay, 20th 6, right?
My lord.
Say the last notice.
My lord.
This is page 102. Yes.
If they receive notice on 12th, and my lord, under the Customs Act, there is a provision. Why can't they file and seek an adjournment that we need some more time or something? They allow the adjudication order to pass an order, then they come before this honorable court, my lord, challenging the order.
No, well, just look at the date of the adjudication order. It's passed on the 21st, on the very next day after the last hearing. The date of the adjudication order is 21/6. Why this haste?
So, my lord, my point is that after receiving the notice on 12th, they don't even inform or seek adjournment, and they don't do anything, my lord, before the adjudicating authority.
My lord.
After the order is passed.
One second. Let's see the adjudication order. Right. Who's present? Order starts from?
Order starts from, my lord,
128.
page 100
129.
129.
29. It's 21/6, my lord. The date of the order. That is the last date of your third notice gave the personal hearing date.
No,
is
where do you
26.
record that they are not present in spite of?
It is recorded, my lord. It is recorded in para.
Recorded that you received notice and they have not appeared. Where is that?
Yes, my lord.
In the adjudication order. Where? That this was placed, that they had received the notice, and in spite of received notice, they have not appeared, and
page
so
one- at page
and so
130
they're going ahead with the
Page
hearing.
139, my lord.
139. Where is that?
Page 139 at the bottom, my lord, para 7, reply to SOCO's notice and personal hearing.
No, where is that? Okay.
Page 139. my lord. Advocate Harish Musha requested for release of the seized good while later dated so and so, and copies are relied upon document while later dated so and so, so and so, so and so, so and so, stating that SCN in
No,
the
the last date.
now the
last date of hearing.
next
that,
parameter.
that where's that? That they've been sent on 7/6, and they have received the same on 12.
But the last para, my lord, briefly it says, my lord,
Where?
at page 139, the last para, my lord, at the bottom, my lord. The notice have been given sufficient opportunity to file written submissions and appear in personal hearing on 6/6/24, 13/6/24, and 20th/6/24. Despite these communications, neither any defense has been advanced by them against the allegation leveled in this SCN, nor did they appear for personal hearing on the scheduled dates. Therefore, I have the option to proceed with the adjudication proceeding based on the facts available on records. Now, my lord, in my humble submission, it is not necessary or requirement in law that 3 notices have to be given, my lord.
But your
Three
circular
is-
might not be
My lord, three-
might not be a statute, but then if your
My
own
lord,
circular
the purpose of 3 notices is that he should get at least 1 notice, my lord, just to ensure that at least he gets a notice. It is not necessary in my humble submission that he should get all 3 notices, my lord.
So whatever it is, they didn't file even one written submission. Nothing.
They have not filed anything, my lord. Neither
Any
they,
show cause also.
they didn't seek adjournment, and SOCO's notice was issued long back to
So
them.
they
my
didn't
lord.
file any.
But my
No, ma'am.
SOCO's notice was delayed, in fact. The
No, wait,
SOCO's
Mr.
notice
Musa
was-
will hear you.
Yes.
Now, my lord, so in my humble submission, once they receive a single notice in time, my lord, and which I pointed out, they received on 12th, for hearing on 20th, my lord, that is sufficient
You don't
compliance.
deserve the consideration also. 20th last date and straight away you pass on 21st.
My lord, when the matter is, date is fixed on 20, my lord, because the commissioner also has to pass many orders, my lord. So when he fixes a date for hearing, he disposes of the matter on the same day, my lord. Now, my lord,
Yes.
now, my lord, what is underlying in this litigation, my lord? Most
The
importantly,
gold whose custody now?
my lord, gold is in no one's custody because there is a master circular
In the
again.
custody of the customs, my lord. Let my friend be forthright.
Then you give them one give one hearing, fix a date.
No, my lord, that in fact, if I may point out this one
We're not going
aspect,
to. We're not going to
let-
release the gold into your custody. You.
my lord, they've already issued in violation of your lordship's interim order as to not to issue coercive actions. They have gone ahead and issued penalty orders. I request my local counsel to kindly hand over the enforcement orders the copies. That scene is passed, my lord. The penalty orders in violation of your lordship's orders was issued to me. In violation of the interim orders. So they have displayed great undue haste, my lord, and the entire adjudication order is marked by undue haste. And it has to go, and the process has to. This is in violation of the interim order.
You can see what.
Notice basically addressed in such a way. So the answer you
6 and 7. What do you do with 7?
whatever the
The thing is that how can they give 6 issue 13, 7 actually issue 14. That means it's just to meet the requirement. But they should undo it. Yes, they can issue after 13. The issue after 10, understandable. The issue is 6 for 13. 60 issue for 24. They never do something. That's one. So when you say 13 becomes a point. Yeah. See, they have to do that. So whatever the outcome, irrespective of the outcome. Let me ask a question. Yes, Dr. Muzika.
My lord.
Now, is it mandatory that every hearing, suppose it concludes the first hearing, what happens? Is circular stance violated? Suppose we issue one show cause note or this notice for hearing, correct? After one, they appear, they file the written submission, they argue, and the commissioner pass order. Will the circular stand violated? If because it mandates 3 show cause, 3 notices.
In my humble submission, no, my lord. 3
My
is.
lord,
No, just see.
Three
Just come back to your circular to that
My lord,
page.
Yes.
3 is the maximum.
117. Yes, just see. Yeah, 117.
Please mandatory one.
No, 117 is what? 117. See. Oh yes. So at least 3 opportunities.
Yes.
So it doesn't stand violated.
My lord, it says, my lord, I'll read the full sentence, my lord.
See, after having given a fair opportunity to notice C for replying to the show cause notice, the adjudicating authority may proceed to fix the date and time for personal hearing the case and request SSC to appear before him for a personal hearing by himself or through an authority. At least 3 opportunities of personal hearing should be given with sufficient interval of time. Sufficient interval of time.
So that
noticing a real opportunity of being heard.
my lord.
Separate communication should be made notice for each opportunity personal hearing. In fact, separate letter for each hearing session should be issued at sufficient interval. Now, can you say the 6 and 7 sufficient interval? That's the only question before the court. Whether, whether the SSC deserves a rehearing of the matter, or whether you can satisfy the court that at 6 you issue notice for 13th, and 7 and next day issue notice for 20th, just to meet the requirement of circular,
My lord,
or is it sufficient time?
my lord, if it says, my lord,
Read it. No, that's only
My
sufficient interval.
lord, one of the sentences says, at least 3 opportunity of personal hearing should be
Right,
given
right.
with sufficient, so that the noticee may avail opportunity of being heard.
Right.
Now, opportunity of being heard is only once, my lord.
Okay, no, now come to, I've read after that.
My lord. Separate communication should be made to the noticee for each opportunity of personal hearing.
Yes.
In fact, separate letter for
I'll read that.
each hearing extension should be issued at sufficient interval.
Yes. Then, now you're presupposing on 7 itself that they won't come on 13th. Is that the case? Sufficient interval means what? Just a common man's interpretation.
My lord, if you look at the date of issuance, but you also looks at the date of receipt, my lord.
Look a common man, just from a common, appreciation. Will like 6 you fix for 13 and you issue next day again for 20th.
So, my
That's the
lord,
only thing that troubles the court.
my lord, my final submission would be that, my lord, if lordship comes to conclusion that there was
Not sufficient time. that's
not
all.
sufficient time given, my lord will kindly bind them that they'll fixing a date that they'll go and appear on that day, my lord. And if they don't go on that day, my lord,
The prejudice is, if I may point out one more aspect, man, if I may take your lordship to page 112 of the writ petition. Page 112 of the writ petition.
Mr. Musa, see, whatever it is, on the facts of the case,
Yeah.
it's a different kettle of fish. This is different. The thing is that what the court proposed to do, give them one point of hearing. If you don't appear on that date, this order will stand. Finish.
No, my
Simple as that.
if I may, there is
Yes.
a specific, the Manipur High Court order that is available on page number 77.
for that they'll have to go to Manipur High Court, my lord. If they want any relief in that respect, my lord.
In fact, that order stands. That order stands, and they have not even managed to get a stay on the order. 78, my lord. The show cause notice was issued with great delay, and the Manipur High Court went on to.
My lord, they want basically release of the gold, and they'll never appear after that, my lord. And this is what always happens.
Who said-
Lordship will
who
not
said-
forbid that, my
Who
lord.
said
They
that?
will
We
pass
are
orders.
willing to.
Yes.
My lord, if I may.
Yes.
On page, the order in page 78 clearly says
Yes.
to release the gold, because the show cause notice was issued with great delay, and they have not secured any stay on the order whatsoever. This is a valid order. In fact,
They should
the
file contempt before
backstory
Manipur High Court for that, my
behind
lord.
the petition, the backstory behind the impugned order is that they wanted to frustrate this order of the Manipur High Court. That is why the notices were issued in a post-haste manner, and the adjudication order was issued on the very next day. And also, my lord, there is a cross-examination of all these people, of all the personnel that is required in the instant case, and which will take at least a few months' time. So, putting the personal hearing is not limited to that particular day, my lord. The examination, the cross-examination of the police personnel concerned, the cross-examination of the officers concerned will take time, and the witnesses. There are 5 petitioners, and there are numerous witnesses, my lord.
Okay, 2 days, you made them all ready.
My lord?
Make them ready, whoever witness you want to. See, the thing is, this order of the Manipur High Court was passed because he did not, the statutory authority did not pass the order, correct?
No, well, because so cause notice was not issued within
The
180
notice
days.
was delayed, was not issued.
Now, now, my lord, so cause notice is followed up, taken up, my
Mr.
lord.
Musa,
Adjudication order is passed.
when this order says you file a contempt before the Manipur High Court?
No, my lord, we did not prefer a contempt petition. We did not prefer a contempt petition, but they went. We did not, my lord. We were under the impression that it will be obeyed.
No, Dr. Mosika's order is still standing till now.
Yes, it stands
I think
to this day.
I'll need instruction, my lord.
Get instruction. Otherwise, if this order is standing, we're having a futile exercise here.
Exactly.
No, my lord. This will be not be futile exercise because, my lord, because one more matter, similar matter is pending before division bench. My lord is in the bench. Now, what happens, my lord? A so-called notice issued. It is something like a default bail, my lord.
No.
Now that
will have an analogy only. Whether this particular order is under challenge in the Manipur High Court.
Most probably, my lord. They'll be.
Just get
I'll get instruction, my
get
lord.
instructions. Otherwise, either the order that will come from this court if nothing is obstructing. You hear it. And you can't put your feet on two boats on the same issue. Simple as that. You should have gone to Manipur High Court if it had usurped whatever
My lord, the
jurisdiction.
cause of action. My trouble is that the cause of action happened.
Cause of action is a continuing cause of action.
Happened in-
They should have gone to Manipur High Court
Yes,
rather than coming.
If this order stands, Mr. Musa, we're rejecting writ petition. You go before the correct High Court. Yes,
my lord, the problem
after
is
hearing
it
at some
merges.
length,
It merges.
the attention of this
It
court
merges.
been drawn to an order passed by Manipur High Court in, where's it?
My lord, the trouble is.
Yes, that's it.
My lord,
Yes.
if I may,
Yes, enough.
it merges.
No, Kasam, merging.
The release order,
In,
becomes
WPC
instructive
766.
because it merges.
In the course of the hearing, it has come to notice of the court that WPC
766 of 23.
certain
My lord,
WPC
if I may.
766 of 2023 had been disposed of by the Manipur High Court.
No, my lord, if I may,
White
if I
order
may
dated,
make
please,
one
please,
comment,
please.
my lord.
White order dated 23/7/2024 on the same subject matter. Learned DHDI to obtain instructions on the status of the said case. This after 2 weeks, yes. We'll see, Mr. Musa. We will pass orders. Don't worry. Let us see. I'll get to the grips of the matter first.
Yes. Obliged.
Any mention?
May I please, Your Lordship? One early listing of one case, my lord. It's in order, my lord. It's fixed on 12th February, my lord.
Why was the urgency?
My lord, the company is suffering, my lord. It's a
BC
tender.
or
No, my
teacher?
lord. Tender matter, my lord. Tender matter, my lord.
Company suffering in which way?
My lord, the tender was issued by the state, my lord. And thereafter, tender without issuing notice, my lord, tender was cancelled, my lord. This is the exactly matter.
So what's the urgency then?
My lord, from last
Why are you
3-4.
a successful bidder?
My lord, yes, my lord. We received the tender, my lord.
For contract for what?
Contract for fiber connection, my lord. In the MECL, my lord. MECL department.
I recall that. That's a
Yes, my lord.
departmentally.
Yes,
So
yes, my lord. My lord, since 3-4 occasions, the state has failed to file the affidavit.
okay,
My lord,
12 days.
on 6th, my lord, day after tomorrow, my lord.
6. Okay, 6.
My lord, deeply obliged.
Yes, Mr. Lindor.
Your Lordship, file a miscase, Your Lordship. This is the matter related with the claim of the petitioner claimed to be locked outside his house. Your Lordship, the urgency is that there is a domestic violence case pending against the petitioner, of which I'm the private respondent in the writ proceedings.
No,
Your
but the
Lordship.
thing is that remember that case is you're there. Who's there? You for a petitioner?
She's young there.
Please, Your
Yeah, but the
Lordship.
case is that there's a 107 145 proceeding there.
Yes, Your Lordship.
So let
The matter is
clear the matter.
No, Your Lordship,
And if
but
they're in
urgency
possession
is
of
there,
that
Your
one
Lordship,
part-
because the applicant here, Your Lordship, she's an old lady, Your Lordship, and there's a domestic violence case pending, Your Lordship, which she has filed against the petitioner.
What,
So
is there
there is,
order- is
she's
there
always
order by
in
the domestic
constant fear.
violence code that they should not come within 10 meters of each other or lock the gate.
Yes, Your Lordship, there's an order, Your Lordship. A protection order is there, Your Lordship, but
This
it's
is a
not.
protection order.
Yeah, tomorrow, Your Honor, they'll be listed. I'll oblige.
Yes.
May it please, Your Lordship. Your Lordship, I beg to mention item number 17.
17.
Yes, Your Lordship.
Yes, Setu Sangma.
Your Lordship. Your Lordship, 3 weeks' time maybe.
Where's the other side? Why 3 weeks time?
3 weeks' time, Your
For
Lordship.
what?
For adjournment, Your Lordship.
Setu, no?
Setu is for disciplinary proceedings, Your Lordship.
There's no urgency.
Not yet, Your Lordship.
Yes, Mr. Gurung.
My lord.
3 weeks, yes.
Oblige, Your Lordship.
Yes.
Please, Your Lordship. I beg to mention item number 24, Lordship.
Number
24.
24, yes.
Yes, Lordship.
Pramila coach,
I
yes.
pray for 2 weeks' time, Lordship.
I have no objection, Lordship.
2 weeks, yes.
Much obliged, Lordship.
Lordship, I beg to mention item 16 for the petitioner. 1-6.
Urmila Devi.
Lordship, I'm praying for 2 weeks' time to take instructions.
What?
Lordship. 2 weeks' time, Lordship.
Who's the other side?
Miss Sham is appearing online. Lordship.
No
Miss
objections, my
Sham.
lord.
Okay, 2 weeks, yes.
Lordship.
Obliged.
Please, Your Lordship, I beg to mention
Obliged.
item number 22, Your Lordship. The matter may come up after 2 weeks.
You have no objection?
No objection, Lordship.
Okay, yes.
Right, Your Lordship.
Much obliged, Lordship.
Please, Lordship, I beg to make a mention of item 19.
This matter will dispose it of
Lordship,
tomorrow.
next week, Lordship. Next week.
After 1 week, okay.
I'll oblige, Your Lordship.
Yes.
Please, Your Lordship, I beg to mention item number 21. Your Lordship, I pray for 2 weeks' time as the conducting counsel is unavailable for this matter.
And for respondent 1 and 2, Lordship, I have no objection.
No objection?
And for respondent number
You have objection or not?
Your Lordship.
2 weeks. Yes.
Much obliged.
May it please, Your Lordship, my Lord, I beg to make a mention of item number 20 on behalf of respondent number 6. Conducting counsel.
Who's for the petitioner?
I'm there, Lordship.
You have you have no objection?
No objections.
3 weeks, my Lord.
2 weeks, okay. When's the arguing counsel coming back?
After the 14th. After 14.
For respondents 1, 2, 3, Your Lordship.
Oblige.
Yes.
Oblige, Your Lordship.
Follow the list.
Item number 1.
What is this?
May please your lordship.
You come for contempt order dated 96.
Your lordship, order dated 6 September 1996.
How can you now? You can't file a contempt now. This how many years ago?
Your lordship, in between, they have filed. The respondent had filed different cases. Your lordship.
No, you're alleging contempt of this order 96. In which way has this order been violated?
Your lordship.
You could contempt 1 year unless it's a continuing cause of action.
Your lordship, we had filed a written complaint last year. Your lordship.
No. You file a fresh petition. Why a contempt after 96 to now? How many years? It's around nearly 30 years. 29 years. No, MSC, I'm sorry. You take instructions. This is a matter after 1 week. You won't retain a contempt from 29 years ago. Same person still there.
Yes.
Committing contempt from 96 till now.
No, Your lordship.
Then?
Item number 2.
Yeah, pieces.
My lord, in this matter, my lord, I was directed to file an application for amending the cause title. So I'm filing the application today, my lord.
Yes. Where's the miss case?
No, in the course of the day, we are filing it today, my lord.
This SD submits that the application for amending process being filed across the day, list after 1 week. Is
for impleading, my lord.
Item number 3.
May it please your lordship, my lord. This is my lord, what happened in this case, my lord. The weighbridge, my lord, UCM, my lord, integrated check it, that was settled.
Weighbridge?
Yes, your lordship. That was settled with me, my lord, 3 years, subject to renewal. Now, my lord, what happened? We filed a renewal application. In 21, my lord, I filed a writ petition, my lord, along with similarly situated 3 writ petitions were filed. Now, my lord, for a direction to renew. Now, these was disposed of by a common judgment on the basis of a amendment made by the Commissioner and Secretary and Commissioner of Transport, that they do it favorably, my lord. So, my lord, that was disposed of. After this, my lord, necessary process was initiated, and in 2022, my lord, an agreement was made for 3 years, lasting till May 25, my lord, the license. Now, thereafter, I was continuing, I have paid up to 25 your lordships. Now, my lord, suddenly in the month of, my lord, first part of 24, my weighbridge was closed down, and the reason they cited, they have not given me any opportunity, reason they cited, my lord, that there is no approval from the government. In fact, your lordship will recollect, my lord, a similar issue came up before, my lord, in a writ petition by one Dipormi Dohar, your lordships. Yeah. Now, there my lord has held, in fact, my lord held that, yes, there was no approval. Now, anyway, my lord, the matter has gone for an appeal. Now, appellate court has held, my lord, the separate approval is not required, number 1. Number 2, commissioner not required, my lord. That's I have annexed, my lord. And my lord, secondly,
by the division bench.
Yes, division bench.
Where's the part? You means while the commissioner secretary is a competent authority.
Yes.
To enter into a agreement by himself.
Yes, my lord. And secondly,
while gone for appeal to Supreme Court.
I don't know.
Huh?
And that.
Honorable Mr. AZ was referring that case.
Anyway, yes.
My lord, only thing, my lord, my fear, my lord, this is still up to me, my lord. Otherwise, it's a covered case. That other case, my lord,
impugn order is March 2020.
No, my lord. Similarly situated person, my lord, can it be given a different treatment? Pursuant to division bench judgment has already been restored.
Learned counsel for the petitioner issue notice, application notice, with Mr. G.N. Ranja are present, except those on behalf of. I will examine it.
All the state.
All the respondent for him to call for. Just up to 3 weeks for.
My lord, that will be too long, your lordship. My lord, time is an essence here, my lord. It's expiring in May.
3 weeks for affidavit. They'll take time again. Yes, try to come instruction. We'll examine it. We'll try to dispose of.
Item number 4.
Is covered.
No, lordship, if it is a covered case, my lord, last down the next day it will be disposed of, my lord.
Yes.
Made plea, Your
My lord, item number 4 and 5, my lord, we fix it tomorrow, my lord. The other matters, all connected matters are coming up tomorrow.
Let these two matters may come tomorrow, my
Place
lord.
that this WPC 1425 together with which other one is
Tomorrow, my lord.
the others, which was this is 14 and the others
14 and 15, my lord.
14 15 is it together tomorrow with other similar matters.
339 of 2024.
339 of 2024.
Yes, please accordingly.
Item number 6.
May I
One
please,
thing,
Your Lord?
Mr. Jindal,
Lordship.
if you're not trusted, just tell a client there's no point wasting judicial time.
Lordship, we are very much interested, my lord. We've been appearing throughout, my lord.
The way this is being conducted, I don't think that all
Lordship.
election petitions, there's been no urgency in the part of the election
Lordship.
petitioner.
Lordship,
Serve
may,
the interests of the respondent, of course, but then there's been no.
Lordship, may kindly recall on the last occasion, my lord, we had brought our witnesses. But the witnesses could not be examined because some petition, which frankly in my humble submission has no legs to stand on, has been filed by the other side. We have filed a reply against that. It's for hearing on that petition, my lord. The allegation in that petition is I have committed perjury. My submission before this honorable court on that last occasion was let the witnesses be examined to help honorable court to decide this petition, the issue of perjury. But witnesses were not examined. So, my lord, we are very much in the fight, my lord.
We're stuck and still in the doorway of this case. Now
outside
now it's come. Now we are sitting 25.
Yes, ma'am.
Elections happened in
23.
So by the time the hearing concludes, it'll be time for next elections.
Lordship, that appears to be the strategy adopted by respondents, but
All over India is the same. You have seen the application for adjournment. Matters has adjourned to when? After 2 weeks for the reasons mentioned therein. Otherwise, if they are not interested, other election petitioners, there's no point.
we are very
burdening the
interested.
court.
We are very interested.
Item number 7.
Lordship, the state respondents are yet to file their counter affidavit, Lordship.
Close to file
State respondents, Lordship.
3 to 7.
Lordship, for appearing for respondent number 8, Your Lordship.
8 is the council.
Yes, Your Lordship. Without
Who's
filing
number 9.
NBCC, they have already
Who's
filed.
number 9?
NBCC.
9 is? What's 9? Then 3 to 7. NG Shilla. She was here just now. She sought more time to file affidavit. Last order. Time was sought on 16/12/2024 for on behalf of response 3 and 7 to file affidavit. Today also the same not on board. For interest of justice, 2 weeks for the times allowed here.
Item number 8.
May please, Your Honor, my rejoinder is ready. Course of the day, I'll file it.
Very good. You didn't inform the council came from Guwahati.
No, I already served him. He's
Already served you, Inder?
yeah.
I have received the instruction, my lord. My lord, as per the instruction received, my lord, the bank cannot disclose the account details of his customer except to the nominee or to the legal heir, my lord. Here in this particular case, my lord, the petitioner, they are neither the nominee of the deceased customer nor they have submitted any.
Who are they?
As per averments made by the writ petitioner in paragraph number 13, 16 and 22, she is the estranged wife, lordship, of the deceased customer. They have admitted, lordship. Now, our stand is that, my lord, we cannot give the account details
You
to
are
a third
appearing for
party.
HDFC?
No, my lord, I'm appearing for the
Bank.
Axis Bank, my lord.
Number 2, you're appearing.
For respondent number 3, Your Lordship.
3 years.
Why is it
Who's
respondent?
file
She is the nominee, my lord.
Okay. And you're appearing for number 2.
No, number 2, Marpan is there, but he is Marpan is there, but he is not appearing today.
Let them file the joinder course, we will finish it off the next date.
Your lordship may direct the petitioner to submit the legal hair certificate to the bank, then we will disclose
File the
it.
joinder. Your joinder is ready.
Rejoinder is
Yes, MSP Parithaji submits the deed of joinder, we file the course of the day. This is a matter of 1 week, yes. For further orders.
Item number 9.
Obliged, lordship.
If that's the case.
Madam, in grant a week's time, the affidavit is ready, we'll file it in a couple of days.
Also, so this is that master rule matter also.
Yes, MSS9 submits that the have no opposition. We'll file within 2 days. Yes,
This is the third time they're asking us.
2 weeks for rejoinder of any. Yes.
Deeply obliged.
Item number 10.
Respondent number 2 have not yet filed the affidavit.
Who has that file affidavit? MPSC. Number 1.
My lord, there is no relief sought against the state, my lord, in so far, my lord.
Yes. Sir, file my affidavit. You file rejoinder to the affidavit filed by the respondent number 3.
We will file if necessary, Your Lordship.
Number 3. Representative for respondents. Number 3, appeal as any third person. Yes.
We will file if necessary, Your Lordship.
You've already filed affidavit, MS Colney.
No, my lord. MPSC is the direct respondents, my lord.
You
who
will
has-
file, no. I wanted to ask whether you will file or not.
My lord, let me have my complete instruction, my lord. We are still awaiting. We are awaiting instruction, my lord.
Ms. Emily Karan for respondent number 2 submits that instruction is just been received. She prays for the allowed week's time. Suffice a week's time to file affidavit. You must ask only a similar prayer just after 1 week for affidavits by respondents 1 and 2 and for rejoinder to affidavit respondent number 3 by the petitioner.
Item 11.
Item 11 and 12 both are connected, Madam Lord.
Yes.
And
I'm praying if this matter can be posted for hearing, my lord, posted for hearing.
Why?
The pleadings are.
Yes.
The admission of the medical.
So the appearing for?
I'm for USTM and medical
What
college.
is admission?
My lord, in the PS Sangma Medical College, my lord.
But that's already been settled.
My lord.
You'll be getting additional seats or something. Will it be accommodated also, I believe, or no?
My lord, in my case, I have not been given any admission.
And the next matter?
next matter is, my lord, discharge of the students, my lord. We will.
Those
I'm
13
taking some time to file the plan.
This is connected to the same admission process?
Yes, sir. Those management quota.
My lord, no, my lord.
Okay, in this item number
11,
11,
I'm for the petitioner.
The council prays that the matter be listed for hearing. Yes, accordingly, this matter for hearing after?
After a week, my lord.
After 2 weeks, yes, don't block the list. Then in the next matter, item 12, Mr. Yep. Who's the counsel? Mali Patil. Yes, where's the counsel? Where's the petitioner?
He was connected.
He was online, my lord.
Yes, he was online.
He was online.
You're praying for time to file affidavit.
Yes, I am praying for time to file affidavit regarding this matter.
2 weeks time as praise allowed to the respondents number 3 to 5 to file. What about 6 and 7?
6 and 7 we have filed.
Already filed.
A statement of affidavit.
Statement affidavit you filed?
5.
Yes, okay. 3 to 5 lists after 2 weeks. Yes.
Union of India and National Medical Commission are necessary party, my lord. NMC is because
Have they been served?
Yes, Mojika.
No, Mr. Mojika didn't appear.
Union of India and National Medical respond number 1 and 2.
None appears for.
No, none appears.
Respond number 1 and 2.
ID card on you. ID card on your receipt.
Right?
ID card 2.
Yes, what's your name? On behalf of Dr. Muzika? You're with him? Yes, MS M. Richiang, why Dr. M. Muzika is present on behalf of respondent 1. Service not complete, respondent number 2. Your file, yeah? Yes, you already been served. But it is permitted to obtain, is allowed to obtain status of service on the respondent number 2. List after 2 weeks for affidavits by respondent number 1. And this is your government is
3, 4, 5.
3, 4, and 5. Yes.
Yeah.
13.
Much worse.
Yes.
Please, Your Lordship, as per the last order, Your Lordship, we have taken steps upon respondents and it was delivered.
Lordship, for this matter, I'm entering appearance on behalf of respondent number 4, Lordship. I'll be filing the power in the course of the day, Lordship.
What about number 5? So,
Yes, ID card receipt.
yes. Mr. B. Kriyam has entered appearance report number 4.
Yes, Lordship.
Number 4. But however, in spite of service of notice, there's no appearance on behalf of respondent number 5. What do you want to file affidavit?
Yes, Lordship.
He prays for and is allowed to file. He prays for and is allowed how much time?
2 weeks.
2 weeks time for affidavit. No appearance is made today also on behalf of respondents 1, 2, and 3. Have you alerted them?
Yes, Lordship.
Yes.
14.
Your Lordship, in this matter also, I'm appearance on behalf of respondent number 4 and 5, Lordship.
Number?
4 and 5. I'll be filing the power in the course of the day, Lordship.
You'll file affidavit?
No, Your Lordship, the bakalan number. Power.
What about number 4?
4 and 5, I'm appearing, Lordship.
4 and 5. 6 has been served. Yes. Okay. Mr. B. Kriyam has entered appearance today on behalf of respondents number 4 and 5. Stop. He prays for 2 weeks time to file affidavit. Though respondent number 6 has been served, there's no appearance on their behalf today. There's also no appearance on behalf of the respondents number 1, 2, and 3. I think you better alert the office. They are not aware. Mr. Bipan, I think you have seen him in court again. Yes.
Hearing 15.
Yes.
My Lord, this appeal, my Lord, we are challenging the order dated 31/10/2022. 31/10/2022 passed by the Special Judicial Officer in East Castles in LA case number 2 K of 2017. My Lord, I'll just give a brief idea about the case and then my Lord will go to the impugned order. So, my Lord, what has happened, my Lord, in this case? In the year 2011, my Lord, there was acquisition of land for the purpose of integrated slum development program. The area of integrated slum development program, and then an area of about 9,900 square feet was acquired. My Lord, notification under section 4 was published, my lord, and thereafter, my lord, the collector
Under the old act.
under the old act, my lord.
When was the acquisition proceedings started?
2011 only, my lord.
2011.
Yes, new act came in 2000.
Where's the land situated? Inside Shillong?
Inside Shillong, Mopra, my lord. Now, my lord, what has happened is, my lord, after the acquisition process has started, the collector, my lord, has made the award, and that award is at page number 60.
Under section 11.
Yes, my lord. Page number 60.
Yeah.
Now here, my lord, if in page number 61, if my lord will see,
yes,
on top, number 7, on top, the first number, amount of compensation allowed for the land itself without tree, crop, building and structure, 42 lakhs 5,971. Now, my lord, if my lord will come to the below portion, serial number 16, it says the total amount of compensation payable to the person interested is 67 lakh 38,032 rupees. And point number 17, my lord, it says establishment and contingency charges at the rate of 10%, that is 6 lakh 73,802 rupees.
10% of?
Yes, 10%. Yes. The entire case is here, that 10%, my lord. What has happened is, my lord, after the award was made, the application was filed by the claimant for referring the matter to the court under section 18. The application is there, my lord. If my lord will kindly see the applications which they have filed. It is at page number 65, my lord. Page number 65.
Yes.
This is the applications which they have filed for referring the matter to the court under section 18. Now, my lord may kindly see the annexes that was enclosed with the applications, my lord. That is at page number 74.
Okay.
Page number 74. Along with their applications, they have enclosed the deed of agreement, my lord. Their claim was that, my lord, there was a tripartite agreement between the parties as regard to the amount. What is the amount to be payable? And on the basis of that one, they have made a application for referring the matter to the court. Now, my lord will see page number 74 is the applications. And my lord may kindly see is 76, page number 76, that is deed of agreement.
Yes.
This they call it as tripartite agreement. And if my lord will see page number 78.
Yes.
Now here the serial number K, the first party agreed to pay the second party an amount of rupees blank per square feet area. When they file the applications for referring the matter to the court, the agreement which they have enclosed, the amount is blank. Subsequently, my lord, this amount has been filled in by handwritten by the claimant, and then on the basis of that, my lord, they said we should be paid this much of amount. Now, my lord may kindly see.
Is this a registered document?
No, not registered document, my lord. Actually, my lord, there was no settlement as regard to the amount. Of course, there was stock, but there was no settlement.
You mean to say the reference court went on the basis of the amount which is entered subsequently?
It has come to the conclusion that there was interpolation. The court has given the finding that there was interpolation in the agreement. Now, my lord will kindly come to the judgment.
Now, has the records come?
My lord, record is
You have to make a paper book then, if the first appeal. Because if you question interpolation on an unregistered document, then we have to examine it also. Because first appeal, we have to reappreciate the evidence has been tendered.
My lord.
What do you say, Mr. Gautam?
My lord, interestingly, my lord, in fact, in this particular case, I should have been the one filing an appeal before this honorable court.
That is
Now
what the next questions will come. How, if you're not agree with the award?
Well, I'm agreed, but I'm at a very fag end of my age, my lord. I don't want to participate in litigation. I'm quite old. Now, my lord, in this case, what my learned friend's
No, there's
ground of appeal.
interpolation now. There's interpolation, but then if the reference court had found out this interpolation and did not go on the basis of this, what's your grievance then?
It did not
My
go
lord,
into it, my lord.
that is exactly, my lord, court did not determine the fair compensation. What it did is, the contingency charges, my lord, that is in terms of the notifications of the government, the 10%, 5%, whatever it may be. That is charged, and it is not only in Meghalaya, my lord, all other states also it does the same thing. They frame under rules. Now, what the court says is, because because the collector did not determine the fair compensation, so it should not have charged the establishment and contingency charges. In one way, the court is saying the agreement itself is fraud. There was interpolation.
Just come again. Now, when the matter was referred to reference court, okay, did the collector adduce evidence there? Did he file a statement?
No.
Did he file a statement or not?
They have
not filed, my lord.
They have not
With my
filed
next party
Did they
against
adduce
them.
any evidence?
They have not, my
To
lord.
challenge the amount awarded. Now they've adduced this thing. Now, do you mean the court on its own did not accept this deed?
My lord, on the basis of record, my lord, court has come to the conclusions.
Fine. The court on its own appreciation of this exhibit, whatever it is, then it did not accept this exhibit, right?
Yes.
To admitted evidence and accepted. Fine.
And
because
gave the
interpolation.
direction to the DC also, to collector,
And what appeal
to
do
take
you have
action.
then? You didn't even file a written statement, or it's not incumbent upon you to file, but then it's for they have not challenged the.
They have not
In
challenged.
the reference code, you have said that the amount fixed by the award of the collector is too less.
Too less, my lord.
And what is enhanced amount from the award?
Well, it was never enhanced, my
It
lord.
was not enhanced. The court did
Then
not determine the
there's no-
compensation, my lord.
Appeal cannot be filed,
What
my
the
lord.
court said is, my lord, that the
What kind of how big appeal is this?
no, my lord, may kindly see the award. If my lord will see the judgment, the impugn order, my lord may kindly see where the problem is, my lord. Page number 32, my lord.
I don't understand really.
My lord, may kindly see page number 32.
If there's no enhancement,
No, my lord.
then what is the
That is where,
problem?
my lord, I'm page number 32, my lord, may kindly see
You
paragraph
didn't
20.
produce evidence, you didn't file a statement, let them take 10%.
My lord, may kindly
Then
see page
one-
number 28,
Which?
32, my lord.
Yes.
Paragraph 28, my lord. It says, this court finds that since the compensation for the land acquired was based on tripartite agreement, there was no occasions for the collector to carry out inquiry to determine compensation. As such, deduction of incidental charges of 10% was not required. The incidental charges of 10% shall be paid to the claimant along with interest at the rate of 12% from the date it was deposited before the collector till it is paid. Now, this incidental charges is never for the claimant, my lord. And it was not even in their claim, and it cannot be claimed by them. What they are saying is the incidental charges to be paid to the claimant, my lord. That is where the problem is, my lord.
Okay. So you want to say that as per the terms of reference,
My lord.
this was not up before the reference court to decide.
No, my
Is that
lord.
your case?
My lord, the court should not have.
See, the thing is that, what in all these matters, what happens is this, right? Now, after section 4, now is section 11, award by the collector. Then you accept the amount of the protest.
They have
Then you
accepted.
file a section 18 application for reference to the court. Then the collector, after examining a reference application, sends it under section 19 of the old LA Act to reference court, right?
Yes.
And then when it comes there, then it's up for consideration again. On what basis are they challenging the award of the collector?
Right.
Right. And they have to show that the award given by the collector is insufficient.
Right.
Okay. And accordingly, it goes by what are the terms of reference which is made before the reference. Before the deputy commissioner, which is sent for reference. Those are the heads or captions of which reference court decide. You mean to say that this incidental charge was never questioned was never put up before the reference court for decision.
No, my lord, this incidental charges is not for the claimant, my lord. My lord is aware.
Should go to whom?
It is for the collector, my lord. There is a notification, my lord, which I would like to place it, my lord.
Well, if I may, just one small submission I want to give. So, Lordship wants a paperwork.
Well, I may be allowed to place my case, my lord, so that I am not.
We have
Yes.
ample time. You place your case today, tomorrow.
My lord, see, my lord, may kindly see here establishment charges. Serial number 3, 20,001 rupees above, 8% plus contingency charges 2%.
This establishment contingency 5%.
My lord, below that establishment charges and contingencies are 2 columns.
So take it to be an enhancement of 10%.
No, my
on
lord,
the order rate.
it cannot be, my lord. My lord, may kindly see here. They have filed the applications for referring the matter to the court. The matter went to the court. Their main contention is not for enhancement of the award. Their contention was based on the tripartite agreement, my lord. And the court came to a conclusion that the tripartite agreement itself is manipulated, interpolated, and gave direction to the collector to take appropriate actions, my lord, criminal actions against the claimant. Now, one way the court held that the tripartite agreement itself is wrong, it's manipulated, and another way, my lord, the court cannot
Then
say
your appeal is not against them at all.
against the order, my lord, by which it was directed that the 10% should be
Only that part.
yeah, only this part. Otherwise, I am not aggrieved by anything, my lord.
The strangest kind of first appeal.
Now, if my lord will, if I can take your lordship through the order, my lord may kindly see. Only the relevant portions, my lord, I will read out. Only relevant
Fine,
portions.
that's fine. I mean, you can
Yes,
read out
ma'am.
everything. But this, you mean to say, this date is 75. Was it placed before the reference court?
This is, my lord, the court is well aware about all these
Was
notifications.
it placed by the collector?
My lord, this was.
Was it? Did you contest the case
I
at
was,
all?
my lord. My lord, whatever required, my lord, it was represented by the.
There was a matter contested at all after they brought this agreement for you to disprove the agreement? Just try to understand again. Now they ask for a reference based on the agreed tripartite agreement, correct?
Yes.
But then there was no amount given there.
Right.
So the court was supposed to fix a fair market value based on the agreement, correct? But since the agreement is found to be faulty, so there's no basis on the court to fix any fair market value, and so the amount ordered by collector was accepted. Is that the case?
Yeah.
And they didn't see anything after that. The matter ended.
Yes.
Only incidental cost over 10%.
Only on the 10%, my lord. There is, my lord, I will just read out the
Okay.
relevant portions, my lord. Then we'll be clear, my lord.
Where does the order start from?
My lord, order is at page number 20. My lord, I'll just read paragraph 6, page number 21.
Who is the GP?
If I'm not wrong.
OP2 and 3 is whom?
SS Das, GP.
You appeared.
Yes. My lord, paragraph 6, my lord, it says, a land measuring 919.74 square meters situated at Lower Moprem was acquired for the purpose of construction of house for urban poor under BSUP project under the Integrated Slum Development Program at the rate of 425 per square feet. The acquired land belongs to the claimant Umesh Changotia. The collector had awarded a compensation of 67 lakhs 38,032 rupees for the land at the rate of 425 per square feet. The compensation was received by the claimant under protest. Being dissatisfied with the amount of the compensation, the collector has made a reference under section 18 of the Land Acquisition Act 1894 for determinations of the fair compensation. The claimant has filed a claim petition praying for establishment of enhancement of compensation at the market rate. The matter was proceeded ex parte against opposite party number 2 and number 3.
So it is Muda.
Two.
Party against you.
2 is collector.
Yeah, 2 is collector, my lord. Void order dated, the opposite party collector has not filed any written statement in spite of given several opportunities. Accordingly, filing of written statement by the opposite party collector was closed. Void order dated such and such. Opposite party number 4 has filed a reply by of affidavit which was taken on record. My lord, may kindly come to relevant paragraph, page number, paragraph 18, my lord. Page number 27. The entire pleading of the claimant revolved around the fact that the rate of the land was fixed and the collector had determined the rate of the land contrary to the rate agreed and fixed. There is no serious challenge to the award being deficit to the market rate. Albeit the claimant has prayed in the claim petition for fixations of the market rate, but the pleading of the claimant is directed towards deviation from the agreed rate. As such, this court finds that it would not be necessary to delve in the issue of fair compensation on the touchstone of Section 23 of the Land Acquisition Act 1894. Court did not determine the fair compensation in terms of Section 23. My lord. There is no dispute that the claimant was paid an amount of rupees 60.
Where are you reading from now?
Paragraph 19, my lord.
Okay.
There is no dispute that the claimant was paid an amount of rupees 67 lakhs 38,032 rupees. Now the relevant paragraph, my lord, may kindly see page number, paragraph 22, page number 30. Paragraph 22, my lord. Upon reading the above provisions, it emerges that when parties have agreed to the satisfactions of the collector on the rate, there is no occasions for the collector to inquire and determine the compensation to be awarded to the interested persons. The copy of the agreement dated 5/12/2008 is found in the MUDA file. However, surprisingly, clause J of the agreement rate of land is shown blank. The assessment order, paragraph 23, my lord, the assessment...
This whenever exhibited,
no, my lord.
Never introduced as,
evidence.
No. Then what kind of proceeding was this?
My lord, collector was...
whatever collector, once you produce a document,
yes,
that has to be tested, correct?
Right, my lord.
Then?
But our file was called and was...
on the basis of the file.
It doesn't work that way, Mr. Nomri.
Exactly.
This is a proceeding under the LA Act. It doesn't work that way.
Right, my lord.
And even the original file has been kept in sealed cover and has not been returned to us.
My lord, only paragraph 23, my lord.
It doesn't work that way. I mean, if you adduce or you produce any documents in support of your claim, that has to be introduced as evidence. If it goes unrebutted or whatever, it was never
opportunity
tested.
has to be given to me also to rebut.
It was never tested.
But never tested, my lord.
My lord, as already in the preceding paragraph it says it went ex parte against the collector also, my lord. Now, my lord, may I kindly see page, paragraph 23.
Even if it goes ex parte against collector, it's the duty of the claimant to
Right,
show
right.
that the rate fixed by collector is wrong.
Right.
The burden's always on the claimant.
On the claimant, that I agree.
Collector is only he's already fixed the ordered amount, given it. Now, claimant, if he can show rebutted, unrebutted, that the amount is wrong, should be more, then it goes in their favor.
Right.
Yes.
Paragraph 23, my lord. The assessment order of opposite party collector is found in page number 67 in the record of MUDA file. The compensation assessed by the collector was at the rate of 4573 per square meter. Total compensation determined was 74,41,397 rupees. Admittedly, claimant was paid compensation of 67,38,032. An amount of 7,03,365 was not paid to the claimant and retained by the collector. Why the court is saying like this is because in the award which I have already taken your lordship, the total amount which is coming to 74 lakhs, page number 61, if my lord will see once again.
There was a decree. There was a decree.
No.
There's no decree.
No.
Well, I was just trying to cut short my learned friend's argument. Just one small point I want
One
to raise.
statement, whatever. I mean, the also degree is.
Well, my challenge is to the maintainability of this appeal. Well, on the ground that, this is not an award. Well, the court has come to a different conclusion altogether. You can only, if Lordship will see section 54, I mean, under provision of, my friend has come under section 54 of the old Land Acquisition Act, my lord. That is very clear, my lord. He can only come if there is an award. But this order is not an award. And my lord, the collector never participated in the proceedings. The whatever transpired in the order which was passed.
That maybe the court will accept that's not an award. Whatever it is, whatever has come out from the proceedings, will amount to award or decree, fine. Whatever, even if it upholds the amount held by award, that's besides the point. But the thing is that what relief only for that amount 10%?
Only for the 10%, my lord, because my lord may kindly.
That is over by application of the notification.
Yes, my lord may kindly see page number 61. Page number 61 is the award, my lord, where the total amount, it says serial number 14.
The most peculiar case in land acquisition, like I have personally encountered. Yes.
Serial number 14, my lord. Serial number 14, page number 61.
Yes.
The total amount of compensation awarded for acquisition of land in question is 67,38,032. This is the only amount which is payable to the claimant, my lord. Now, the 17 is the contingency charges, that is 6,73,000. This is on the basis of the notification, that is 10%. This amount is never for the claimant. And the next page, my lord, 62, the total amount is coming to 74,11,835.
Then it is an application of 227.
Now, my lord,
how limits it?
Now we are only concerned, my lord, the order itself is wrong to the extent giving direction to the collector to pay that amount of compensation, that is 6 lakh some amount, to the claimant. My lord, this was never in their claim, and it cannot be claimed. If there is, my lord, no enhancement by the court, they could have filed an appeal, my lord. It is their prerogative. But the court did not determine the fair compensation in terms of section 23.
Well, that we've been paid. The only that
in terms of section 23, court has never determined the fair compensation. Now,
the other amount is already drawn by you.
No.
74, that's still withheld.
The total amount, my lord, 67, entire amount has been drawn.
The extra 10% still with you.
Still with them.
It is with the collector, my lord, because
what kind of order can this court generate then? Is a very peculiar case.
Only, my lord, we are aggrieved only by that direction, on to the extent, because
then the first appeal also it's.
Well, I still say appeal is not maintainable.
My lord,
they could have filed a revision 53.
54, it clearly says, my lord.
Clearly says the honor clearly
An
says.
appeal shall only lie in any proceeding under this act to the High Court from the award or from any part of the award of the collector or from any decree of the High Court. Yes.
I say it's not an award, my
But
lord.
you're saying it's a procedural relapse.
So, well, revision will
We are
be
agreed by the
maintainable.
order of the special judicial officer to the extent, my lord, directing the collector to pay the amount 10% to the claimant, my lord. That was never.
My lord, the
part of
reason
the
why
claim
that
also.
order is passed is because, my lord, the entire, according to us, my lord, it was decided on the basis of a agreement. Now they don't dispute that an agreement is there. Now agreement in Muda file is blank. The amount is blank in Muda file. In my file there is some amount. Now, my lord, what exactly happened is when the meeting happened, when the meeting transpired, my lord, at that point of time the thing was left blank because we were not decided what should be the amount.
Now, why didn't you introduce your document into evidence?
Well, that.
In their own application, my lord, they had given a blank documents, my lord.
Connected the case very.
No, but what I see is, my lord, when the collector did not even participate in the proceedings, and my lord, that particular document.
That's to your advantage. Did you introduce an agreement in evidence as an exhibit?
Well, I think it must be there, my lord, because we file our affidavits.
As an exhibit,
as an exhibit, well, I think because.
Has you recorded
the way
that
the matter was,
the document, although unregistered, has been introduced into evidence?
I'll have to just.
And moreover, this agreement is prior, my lord. Acquisition started in the year 2011. My lord, this is prior to the notification, my lord, of under section 4. My lord, may kindly see the date of the agreement.
The rate at which we're not bothered about that. Yeah. Court sitting here is only concerned about the proceeding for the reference court.
Yes.
Whether the award is beyond appeals are normally filed when the award is is not fixed on a fair market value, or whether there's no evidence adduced to allow the reference court to come such an amount.
Yes.
Or whether the court did not appreciate that although materials were adduced to show that, they were placed before the court, expert opinion taken, that this is the fair market value at that relevant point of time when that land was acquired, it should have been paid instead of amount X, amount Y was paid. This is what, an LA appeal concerns.
Yes.
Not with regard whether a portion is kept with you or given to him.
Now here, my lord, the special judicial
You
officer
paid court
did not
fees also on
determine.
this.
Yes, my lord, we had to pay the court.
Fantastic.
Court did not determine the fair compensation, my lord.
There's no question
On the
of
other
I
way,
should
my
file
lord.
an appeal instead, my lord.
But we are concerned about the 10%, my lord.
425 rupees. Now his agreement which he produces before the court is 650.
That is interpolation, my lord.
What is the difference, Lord? On that basis?
What a collector can be.
Has
any amount of
interpolation been
robbery.
proved, my lord?
But the thing is that he never introduced that in evidence to say that to call the witnesses who were signatories to the agreement to say that at that point of time it is 625. If he had been able to do that, this is we're just talking, outside the proceedings. Like if suppose in a normal course, he would have filed a reference application saying that fine, this 425 is less, agreed amounts to 625, and this agreement to prove it. And then he was introduced agreements evidence, marked as an exhibit, called the signatories to say whether it's a fact or not 625. If it's a fact, then the court say, okay, fine, you should pay 625. He didn't do it. The collector didn't take part. So nothing happened. There's no proceedings, only he's agreed with the amount.
That's why, my lord, there is no appeal also, my lord.
Even
That's what I say.
my lord, even for agreement, if there is such agreement, there is a procedure under section 11 clause 2.
Forget about that.
Yes.
Forget about that. I'm saying that you didn't attend the hearing, nor you filed a statement, nor is evidence. They also never introduced that. So there's nothing to award, nothing to compensate.
That's why, my lord, I say the appeal.
But we are agreed by the part of the order, my lord, which says
which you seek him to by seek for
on by way of a notification.
My lord, this notifications is already under implementation, my lord.
Under what provision of laws is made?
My lord, these are under section 55. There is rule making power, my lord. Other state also makes the similar.
The rule is an executive order.
My lord, even other states also, my lord, they frame rules and then such not.
Where are the rules?
My lord, here, my lord, I am not aware because whether the rule has been framed or not.
You see,
because the notification says
all this have under Assam that has state acquisition and
yes.
acquisition rules is there. Whether it's
Yes.
adopted or not.
Yes.
Well, I say that appeal is
Yes.
not maintainable at all. Procedural lapse 53 is very clear, my lord. CPC is applicable. Revision can be filed. Could have been filed.
Kindly see the conduct of the claimant. First of all, my lord, the agreement has been manipulated.
What conduct?
How can we say, my lord? Has it been proved they have manipulated in the first
court
place?
has held, my lord.
See, Mr. Singon, you can't attribute that kind of submission. How can you say that conduct? He never bothered to adduce it also. How can you say that it's bad conduct?
No.
He never claimed anything.
Just
It's
filed.
been given by, it's given
On the
given by
basis of
reference
that,
court. It takes
on
it
the
for
basis of that agreement, my lord, the reference was.
Yeah, but then
My lord, interestingly, my lord, in the file of Muda, that particular amount is blank. So there is interpolation over there also, or lack of it in the first place.
no one both of sides conducted the case very poorly. That's one. Simple as that.
Well, as far as
We are only
maintainability is
aggrieved
concerned,
because as they have not preferred the appeal also, my lord. If they are aggrieved, because there was no enhancement as far as the award is concerned.
See, they have not preferred an appeal for.
we don't want to participate in any further litigation.
And you have come for procedural lapse.
My lord, may kindly see
Not
whether.
a question. See, it's not a question of entitlement.
Yeah, it is not a question of
Question
entitlement.
procedural lapse on your part. He said that the court was wrong giving it to them instead of keeping it with you.
Yeah, that is where my problem is, my lord.
Let's see your pleadings. And you paid how much court fees? Yes. And where's your pleadings? Your grounds of appeal.
My lord, grounds of appeals, page number 11, starting, my lord. I'll just read out, my lord, the number 1 ground, my lord. The learned special judicial officer, Iskasils, has wrongly disposed of the appeal so by holding that the claimant is entitled to 7,03,365 only, which was retained by the collector. It was further held that since the compensation for the land acquired was based on tripartite agreement, there was no occasions for the collector to carry out inquiry to determine compensation, as such deductions of incidental charges of 10% was not required, and hence it was directed that the incidental charges of 10% shall be paid to the claimant along with interest at the rate of 12% from the date it was deposited before the collector till it is paid. But in reality, the incidental charges / establishment and contingency charges are not meant for the claimant and but for the collector in order to initiate the acquisition proceedings and for taking up the work of assessment of rates.
Where have you written about this thing, about this notification?
Well, notifications.
There's no ground appeal with regard to that also. Where's the ground?
My lord, my lord, here grounds, all grounds I have mentioned here.
Well, where's the ground you mentioned regarding essential charges which should not have given to them? Where's that? Show that ground. Why are you harping on this agreement? The agreement is not in question at all. It's not been acted upon by the reference court. They're not bothered with it. So there's not a question of appreciation by this court. Remember, Mr. Conveyor in first appeal. So it's not a second appeal or some in first appeal where this court can reappreciate everything.
Here, my lord, I have stated here, incidental and contingency charges, my lord, are not meant for the claimant. Here only, same paragraph, page number 12, not meant for the claimant, but for the collector.
On what basis? See where?
On the basis of the notification, my lord, which I am placing.
Where said that?
My lord, the first ground only, page number 12, the continuations.
No, where do you say it's wrong? On what basis? That why the order is bad? Well, as per so and so, this cannot be credited to the claimant's account. Where is that?
That is why, my lord, I said this.
That is where,
this 10%, my lord. It is
where
not.
Have you said that?
Here, my lord.
Where
let me read.
You in first appeal.
I have not. This was not part in the part of the.
Too bad.
My lord, may kindly see here page number 83 of mine. Page number 83.
I don't understand it.
Notification. Page number 83. This is one notifications I have enclosed, my lord.
Before the reference court.
My lord, this was not in question only, my lord. This contingency charges, my lord, because it was not in their pleading also, my lord. In their claim petition.
Why should they wouldn't know about it also?
That is why, my lord, we are also not aware. All of a sudden, my lord, all of a sudden, my lord, court says you give the 10% to the.
You want to
claimant.
pass a very
It was
order,
not.
like,
it was.
It will writing all these things will happen.
My lord,
how an LA proceeding has been that it will be like a handbook how not to conduct an LA proceeding by the collector.
My lord, may kindly see. It was never in their claim petition. There was no claim.
Don't go to them.
Yes.
It's just concerned with you only.
Yes. Now, if my lord,
done anything.
My lord, I am ready to reply, my lord. My lord has asked about the notification.
I don't want to argue with the councils, but then seeing such cases,
my lord has asked me about the notifications. These notifications particularly. Now, we would have placed these notifications, my lord, if there was any averments in their claim petitions, my lord, as regard to that they want the contingency or establishment charges because the collector did not take the take up the acquisition proceeding. There was no claim or averments from them, my lord. Therefore, there was no occasions for us to place this notification before the court. When the order comes from the court, my lord, the court gives the findings that the collector did not take up determine the award. Therefore, the amount of 10% should not be kept by him. It should be paid to the claimant, my lord.
Read this 2020, which is 3 again. Read it slowly. Read it.
83, page number 83, my lord? Yes. Whereas the appropriate government has to specify an administrative cost for acquisitions of land in the project site out of project area land, not exceeding the percentage of the cost of compensation under paragraph so and so, right to fair compensation and transparency in land acquisitions, rehabilitations. My lord, this is as regard to the old act. My lord, the notifications was at that point in time when we filed the case, it was not available. Therefore, my lord, we have placed it before this court today, my lord. This is kind of notifications.
This under new act.
This is under new act,
Then
but the notifications.
Then you should have placed this under the old act.
Old act, my lord.
Yes.
Yes, but these notifications which I have.
It's not a question. Why did this court ask whether the court is represented or not? Government pleader is recorded there.
Yes.
Then
Government pleader was definitely there, my lord.
Then?
But
When ex party against 2 and 3, that means Buddha.
No.
One is the collector, my lord.
One, then who ex party?
Them. When ex party.
When political lordship.
And one also.
Yes, one. All of them. Except for the headman.
Only the headman filed an affidavit and it was taken as a written statement, my lord.
Page 22.
So, my lord, when you did not even participate in the proceedings, now you want to file an appeal. Doesn't make sense, my lord.
My lord, if we agree by the order, even though, my lord, of course, there was a fault on our part, we can definitely file for appeal, my lord.
OP number 2 and 3.
That's Muta.
See, that's Muta. So the OP director has not filed a statement in spite of being given responsibilities. Only filing is closed. He didn't go ex party.
Yes.
Then he was represented.
He was represented by the
He didn't
SSS.
show this notification also.
My lord, there was no occasion for even the.
So where is submission? Did they record submissions anyway? The submissions made by the government council.
In the judgment, my lord.
Yes.
No one's name, my lord, mentioned here.
So this when totally the reference code.
My lord, here only says, my lord.
Pass order. No one appeared.
Leonard GP SS Das for OP number 1 collector present. Only this much, my lord.
Sharma was there for the claim.
And then for
Sharma was there for the
I Rani for opposite party number 2 and 3 present. They were also present, my lord. 2 and 3. And
one ex party against them.
for opposite party number 4 present.
This was again issued to us, and the original file was called.
For 4 also, my lord, Sri P. Lingdo was present.
Please get this 71, whether it's applicable or not. The CC, the state has its own acquisition and requisition. It's called acquisition and requisition rules or act. Every state has that also under the old act. Because this appeal,
My lord, we are only aggrieved by only that part of the order, my lord, because
we understand.
I'll try to place some judgments, my lord, on the maintainability here, my lord. Because I say
But
revision
give
would
judgment
have been
example.
maintainable, but
You
appeal-
just give a citation. We'll have this matter another day.
But I don't have it right now, my lord. I'll place it.
Yes,
my lord.
please. It very interesting.
You can have it on the next day, my lord.
Should we
Because
have
in
a
fact, well, I
composite
should have been
judgment
the one
writing
fighting
the will this court go to exercise of writing, it's like a funny story, where even the claimant also doesn't adduce an evidence, the character doesn't appear, doesn't file a statement. It goes ex parte against 2 and 3,
And my lord,
and then a judgment, and then you agreed with it, and you
And
come.
my lord,
You're not bothered from the beginning.
very surprisingly, my lord, the court came to the finding that court is not necessary. It is not necessary for the court to determine the amount of compensation. And then court held that the agreement on the basis of which the claim petition was filed, it is found to be interpolated. And thereafter, court gives a direction.
Even court, not criticizing the court, how can they just look at the records as if it's a summary proceeding? It's a proceeding of the LA Act.
Yes, my lord. Court should not have given direction at least to.
They can't give direction also. They can examine the file and send it back. But then if you don't adduce the agreement, court didn't have to look into that also. List the matter after 1 week is for further hearing. Parties to submit authorities in the meanwhile. Contentious case.
18.
Acquisition matters are very hard fought because claimants come, they bring all sealed deeds and this and that to prove at that relevant point of time in more prem this here was like that. That is what is done.
Yes.
Even if you don't have an agreement, then they produce that from adjoining areas or seals that have been transacted.
Yes.
No, here, my lord, he had produced a sale deed of his own adjoining land which he has sold. And in fact, my lord, had it happened after 2013, they would have to pay so much more compensation. So I don't think so. I will been filing an appeal.
18.
Obliged, my lord.
Please, Your Lordship.
Yes.
Your Lordship, on the last date, the question of tortious liability had come up. Your Lordship, I pray for some more time to prepare the matter.
Interesting case.
Yes, Your Lordship.
Yeah, there's one case I think a long time ago. It's in England, reported case, but I've won citation. So there was a lady who was carrying, right? She was in a building, and there was an accident which she didn't see, which happened round the corner of the block.
Yes, I'm
You know
aware,
about
Your
that?
Lordship, yes.
And so it caused shock, it caused a miscarriage, or it caused she sued for the liability of those people who caused the accident, whether
Yes, Your Lordship.
you're appealing for the petitioner.
Here,
That doctor who died.
Yes, Your Lordship.
Okay, list up to 2 weeks. Yes, to allow the respondents to come up with to prepare the matter further.
Obliged, Your Lordship.
23. 23.
Affidavit filed.
My lord.
Affidavit filed.
Yes, my lord.
In this matter, Lordship, the managing committee is represented by S. Pandey.
Who's S. Pandey?
S. Pandey. He's a lawyer from here, local lawyer. But
Pandey,
he's not there today.
Even
managing committee is necessary party.
Necessary party, but the conduct of the managing committee, my lord. Here,
You
it's
inform
not
him,
payment
take
of
it up,
salary.
We'll take it up day after tomorrow. It's urgent.
My lord, I've been teaching there. I've not been paid since 2022 as a teacher's
Where's Mr.
salary
Pandey?
matter, my lord.
No one appearing on his behalf.
Nobody is appearing.
And even the state government's where my
Supporting
friends
your case.
supporting my case is saying that we have approved. They are not giving the statement.
No, not exactly supporting, Lordship, but till date,
Yes,
there
when
is
the
no
matter is
budget
taken up,
proposal.
there is counsel for the managing committee. Mr. S. Pandey is not present.
Not present.
This is matter up to 1 week. Is expected next day.
My
The counsel is present, failing which the matter shall be decided
My lord.
ex parte.
My lord. Grateful.
Obliged.
You inform them.
My lord.
But really funny case, Ellie case.
No award.